Explanation.
I know that the history does not dictate such an offer. I think there are some extenuating circumstances that I took into consideration. One being the underlying offenses themselves. I think her co-defendant, Brandon Lewing, who's also said before the court, is actually the more culpable party, especially in the UUMV. His case was supposed to be resolved last week, and Mr. Smith ended up withdrawing from that case. So it is still pending. Ms. Jordan has agreed to cooperate.
Good morning. Are you Sarah Jordan? Mr. Rojas, will your client waive the formal reading of the indictment in each case?
She will, Your Honor.
Ms. Jordan, in cause number 25 DCCR 1401, you're charged with a state jail felony offense of unauthorized use of a vehicle from February 21st of 2025. That indictment also alleges that you were previously convicted of the state jail felony offense of possession of a controlled substance, July 26th of 2013. And after that, you were convicted of the state jail felony offense of possession of a controlled substance, November 16th of 2017. And then after that, convicted of state jail felony offense of theft, January 26th of 2022. And on that same day, also a state jail felony of possession of a controlled substance. And then after all of those were final, you were convicted of possession of a controlled substance, a state jail felony, January 5th of 2024. How do you plead to that charge?
Guilty.
And are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty in that case freely and voluntarily?
Yes, ma'am.
And also your pleas of true freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they've charged you
Yes.
with?
And Judge, at the appropriate time, I know the court will need an explanation as to why I made the offer.
Okay, good. Just a second. All right, then we have clause number 25, DCCR 1403. And in that case, you are charged with a state jail felony offense of theft of property with previous convictions from June 4th of 2025. It alleges in this indictment that you were previously convicted of theft August 7th of 2007, and then again, January 26th of 2022. It also alleges those same prior state jail felony offenses as well. And how do you plead to that charge?
Guilty.
And are those prior convictions all true?
Yes, ma'am.
And again, in this case, did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And because you actually have done what they've charged you with?
Yes, ma'am.
In both of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Explanation.
I know that the history does not dictate such an offer. I think there are some extenuating circumstances that I took into consideration. One being the underlying offenses themselves. I think her co-defendant, Brandon Lewing, who's also said before the court, is actually the more culpable party, especially in the UUMV. His case was supposed to be resolved last week, and Mr. Smith ended up withdrawing from that case. So it is still pending. Ms. Jordan has agreed to cooperate against Mr. Lewing if necessary. He actually has about twice as many priors as she does. It's also my understanding that when she discharges from TDC, and correct me if I'm wrong, that she's been accepted into a women's center type program. Invite her to try to help get her back on the right track and keep in touch with me so that if we need to use her cooperation, we can. That was my thought process when making this offer. I certainly understand if the court doesn't think it's appropriate.
No, I appreciate the explanation. Ms. Jordan, each of those cases I have here on the tablet, these documents that have your signature on them, that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand this?
Yes, ma'am.
And you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Also want to make sure you understand if I go along with these agreements and you're back here on any other felony, I'm going to take it pretty personally, and probably Ms. Malfino will too. You're not going to get deals like this again. Do you
Yes, ma'am.
understand?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation,
Yes, ma'am.
exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number one in each case.
Objection.
It's admitted in each case. Is there any evidence that Ms. Jordan is not competent?
No, Your Honor.
All right, ma'am, in each of your cases, I'm going to find that you entered your pleas of guilty and true freely and voluntarily. In cause number 25, DCCR 1401, find sufficient evidence to find you guilty. At this time, find you guilty of unauthorized use of a vehicle. Find those prior felony convictions true. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Thank you.
Cause number 25, DCCR 1403, also find that you entered your plea of guilty and true freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of property. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm handing you the trial court certifications in each of your cases that shows these were agreements that I followed, so you waived your right to appeal.
Yes, ma'am.
I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
Yes, ma'am.
Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. Excuse me. All right. Thank you, ma'am. You go back with the bailiff.
Thank you. Thank you so much.
After multiple prior felony convictions, Sarah Jordan pleaded guilty to 2 new charges: unauthorized use of a vehicle and theft. The judge accepted the agreements but delivered a serious warning. This was her chance to turn things around. She was sentenced to 3 years in prison on each case, running concurrently. And the judge made it clear, if she comes back on another felony, there may not be another deal like this.
All right, Mr. Bennett. So I want to go through your indictment with you. In clause number 25, DCCR 0718, you're charged with a 3rd-degree felony offense of deadly conduct, discharging a firearm, and that's from March 4th of 2025. Your indictment also alleges that you were previously convicted on July 17th of 2015, 2 cases of deadly conduct, which are 3rd-degree felonies. After those were final, you were convicted of manslaughter, a 2nd-degree felony, November 27th of 2019. What that means is that if you go to trial and you're found guilty in this case, and if those prior convictions are true, you would be considered a habitual offender, which means your minimum punishment would be 25 years up to 99 years or life in prison. Do you understand? And I have the plea bargain rejection that you've signed this morning with Mr. Adams that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go forward probably on just one of those priors to make it a 2nd-degree felony with a 20-year sentence in prison. You have every right to reject that and have your cases set for trial. Just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial? Mr. Nichols, is there any reason to believe that that offer would change?
No, Your Honor. If he's found guilty at trial, we'll be proceeding on the habitual enhancements, and we'll ask the court to stack his sentences, Your Honor.
I do want to make sure you understand that after today, I will not accept this plea agreement. If something changes, there's some information that comes up that either your attorney or the district attorney doesn't know today, then we'll talk about it. But other than that, once your case is on the trial docket, it's expected to go to trial. Or if you change your mind and you want to plea, it would be to something different than this. Do you understand? All right, we'll get your case set for trial. Mr. Adams will begin preparation.